anniversary of the inauguration of our court. Date back 21 years ago, in March 9, 2001, is the first day that the administrative court, has has been in Thailand. Today is a good opportunity to look back and look forward, to acknowledge what we accomplished and what we want to achieve in the futures. And that's leading to today activities. Starting at 9 o'clock, there will be special lecture by our own Professor Dr. Charnchai Sawangsagdi, President of the Supreme Administrative Court, on the lecture on the 21st anniversary of the Administrative Court Inauguration, elevating the administrative justice and strengthening good governance in the society. And later on at 10 o'clock, there will be seminars on the Administrative Court in the view of independent institution by the Constitution, which today we have been honored by our guest, Mr. Somsak Suwansucharit, President of the Ombudsman, and Police General Dr. Wacharapol Prasanratthakit, Chair of the National Anti-Corruption Committee, and Ms. Sayamon Grayun Wong, Commissioner of the National Human Rights Commissions. All of our three honorable guests will share their view, which will be useful and benefit to the work of our court. And that's the schedule for today. You can view the lectures and the seminar via Facebook Live on our Facebook page of the Administrative Court, and also on YouTube channel of the Office of the Administrative Court. And today you can download document of this lecture and seminar via that channel. And for our international audience, the Administrative Court has provided English version of the lecture by President of the Supreme Administrative Court through the Office of the Administrative Court YouTube channel. Just simply click the link in the OAC Facebook and watch the live broadcast there. You can also download the lecture and the symposium document by clicking the link that we post on our Facebook too. And now, all our honorable guest is ready. We're now ready to commence the first activity, the academic activity for celebrating the 21st anniversary of the Administrative Court Inauguration. Please welcome Professor Dr. Charnchai Sawangsagdi, President of the Supreme Administrative Court, to give lectures on the topic of the 21st anniversary of the Administrative Court inaugurations, elevating the administrative justice and strengthening good governance in the society. Good morning, ladies and gentlemen. Greetings, our colleagues, President, Vice President, and the Executive of the Administrative Court, and all the delegates from Ambassador, from the Embassy, and the Foundation, Konrad Adenauer Foundation delegates, and all online audience. I have been tasked with the committee on this seminar to give lectures about the 21 year of court. First, I would like to go back in history to honor the one who helped creating the court. Now I wrote an essay in the ebook versions for you to download, and today's lecture will be divided into 3 parts. Section 1. Before establishing the administrative court is the difficulty in the formation of development of the administrative justice system in Thailand. Section 2 is previous step taken by the administrative court by enhancing administrative justice. And Section 3, the next step, strengthening good governance in society. Section 1, for the difficulty in the formation of the court, we have 5 issues. First issue is that Thailand has adopted a dual court system. The separation of private law on civil law and public law or the administrative court. But legal education in Thailand has been influenced by common law traditions, including that of civil law, criminal law, and a single court system. The distinction between these two systems, the common law has originated in England or the British Empire. So the colonized country that have been colonized by British will use the common law. Vice versa, the civil law was created by the Westerns, such as France and Spain. Then due to the colonization of the Western country, like France and Spain, they have created the state or the nation under the colonization to use the civil law. In contrary, common law use the case law, while civil law use the code, a codified law. To simplify it, common law believe in the one legal system and one court, while the civil law believe there can be more than one jurisdiction on certain cases. In Thailand, we use civil law system. However, we have been influenced by the common law system. For example, the rule of law is translated from the rule which was developed by Professor Albert Van Dicey, a British jurist and a constitutional theorist. The rule of law is set as one of the fundamental principles which every member of Council of Europe must accept. The rule of law in the English-speaking country is one of the major theory of law. one major one major distinct of the English speaking country is single court system is that they deny the existence of the dual court. While the civil law is this for legal state, it's a different definition of the rule of law. Nitirat, or the legal states, is a government of law, not of men. It was originated in German and was later translated into the legal principle in France. As for Thailand, King Rama V has decided to use civil law as a legal system. And in our system, the rule of law has been defined in our constitution. Concept of the common law system is that no division between private and public law. All persons, both individual and state official, must be equally subject to the same law, while the civil law system is a division into private and public law, and there is a multi-level court system. The second problem is in Thailand, we give importance to the civil law legal system. For hundreds of years, we have been, all the dispute has gone to the courts of justice, while the administrative legal system has been inaugurated just 20 years ago. The fundamental concept in public law is different than the fundamental concept in the public law. Private entities are equal before the law. Each private entity aims for its own benefit, and most legal relation between private entities is written in contract. While the public law is public interest, it's the most important. All the legal structure in Thailand is under the public law. The state, through state agency or state official, is the caretaker of the common interest of the majority of the people in the society, or the public interest. If private entity fail to provide individual benefit for the public interest, the state, through state agency or state official, can legally enforce private entity to do so. And the scope and development of the administrative law is that can divide into two: substantive law and regarding procedure. Administrative law has not yet been developed systematically. Therefore, there is still no general administrative principle which can be enacted in a single legal provision. There are only specific administrative law dispersed in various law boards of act and subordinate legislative level. Most of the act level law, approximately 800 laws, is entirely or partly about administrative law. Most of the subordinate legislation, approximately 100,000 laws, is about administrative law. In terms of quantity, since the administrative law is vastly in our life from birth to death, all of the law and subordinate legislative involves, it's the administrative law. What I have said is not what I made up, but is part of the problems and what is really happened in the administrative law regimes in Thailand. For today, we want to honor the individuals, the independent institution in the Constitution, and the evolution of the administrative legal system, administrative law legal system. It started with the Constitution in the 1997. The control of the use of the power of the executive branch, administrative branch. The 1987 Constitution was the first Constitution that that organized the state agency in controlling the exercise of power is in compliance with the type of the power used. For political problems, it's House of Representatives and Senate. It's strictly political issues, and they have accountability to the people, not the court. For corruption and misbehavior problem, it's the National Anti-Corruption Commissions and the Criminal Division of Person Holding Political Position of the court. And for fiscal problem, the State Audit Commissions and Disciplinary Finance and Monetary Commissions. All aspect of the exercise of power of the administrations has been supervised and regulated by many organs. The direct control and review is the administrative court. As for other dispute, such as criminals or fiscal problem, is under the supervisions of other organizations. For legal lawfulness, constitutional case is the Constitutional Court. Civil case and criminal case is under the Court of Justice. Military criminal case is under the Military Court, and the administrative case is the Administrative Court. The control of administrative branch by independent organization, namely, is the Ombudsman, National Anti-Corruption Commissions, State Audit Commissions, and National Human Rights Commission. The control of administrative branch by filing lawsuit and petition to the court is under the Administrative Court, the Court of Justice for civil and criminal case, as well as administrative case under jurisdiction in the Court of Justice. As we establish a dual court system, which inaugurate the Administrative Court in 2001, the administrative justice has been growing, and the role of the court to protect the right of the people and the right of the officials has been clearly noted. Since the evolution by the Constitution of 1997, we have all sorts of independent organizations that helps guarantee the rights of the people, and we don't have to obey the wrongful act of the official or the administrative no more. That's why the mission of the Administrative Court is very vital and important to the development of administrative justice. in the past, each organization and organs has been separately worked on their own, and sometimes our jurisdictions is collide, and sometimes we run into troubles. Nonetheless, this issue has been resolved by the cooperation between the independent organization such as Ombudsman, National Anti-Corruption Commissions, and the State Audit Commission. Now it's working hand in hand. Since I been in the position of the president of the Administrative Court, I have visited the president of the Ombudsman, and we exchange ideas, and we create a cooperation academically, and from my experience as a law student in France for 8 years, what I achieved during that time is that different between academics and scholar is very common. It's very common to have different ideas and angles. Nonetheless, everyone can cooperate under the same goal to certify that the justice in the administrative justice system. The control of the administrative branch by filing a lawsuit petition to the court. Thailand has been enhancing its administrative justice system for 21 years. Since inaugurating the Supreme Administrative Court, the Central Administrative Court, and 14 regional administrative courts. However, the establishment of the administrative courts provides it just a hardware or a tool for developing administrative justice. In the aspect of software and knowledge and understanding and the peopleware, which is relevant personnel, it's still insufficient, and there are not enough peopleware in our administrative justice system. The reason is that the curriculum of the Faculty of Law in universities and the training course of the Thai Bar Association and the Lawyer Council still emphasize the study of civil law, criminal law, civil procedure law, and criminal procedure law. Consequently, our country lacks the ability to produce lawyers with expertise in administrative law and administrative court procedure law. So the lack of software has been solved by the work of our court. As for peopleware on the personnel in the administrative personnel, an administrative judge is lacking in numbers at the moment. We derive a system from France. So the French system is the role model that we upheld to. In France, the administrative judge, the ideal administrative judge, should have 3-in-1 qualification. Qualify in a field of administrative law, have knowledge and understanding of the problems of public administration, and have an awareness of the importance of maintaining balance between private interests and public interests. On the civil case, the balance between the interests of the party is between the plaintiff and the defendant. But in administrative case, it's different. One is the private interest and the other is the public interest. Thailand has a shortage of administrative judge with the above mentioned qualification. A course in administrative law should be included in the curriculum and training courses offered by educational institution. To address this matter, Thailand has a shortage of administrative judge with the above mentioned qualification. A course in administrative law should be included in the curriculum and training course offered by educational institution. Additionally, relevant officials including state officials, lawyer, public prosecutor, administrative judge, and an administrative case official should be provided with knowledge of administrative law. Professor Dr. Amon Chantarasomboon, former Secretary General of the Office of the Councils of State, and Professor Dr. Charnchai Sawangsagdi, former Secretary General of the Office of the Administrative Court, recommend improvement to the curriculum and training course on law. These recommendations not limited to just university education, but also to the level of elementary, secondary, and high school. The administrative law has been involved in all part and aspect of life since the day you were born until the day you die. So we should educate administrative law early on for students to know what's the law and regulation which will involve with their life. As for people where the important issue that we face is the lack of administrative judge. For the problem of the backlog case in a court, it's mostly rooted by the process on the fact that we lack a number of administrative judges in our court. The process of selection and training of judge of an administrative court of first instance and the Supreme Administrative Court takes too long, and the number of judges select is not sufficient to handle the caseload and a different type of administrative cases. For administrative court, there's a lot of aspect to it. It's not judge limited to the regulating law or ordinary administrative law, but it's also involved telecommunication and other aspect of law as well. The selection system of an administrative judge is very open. The problem, you can check out the slide number 37. Period of time and budget spent on the selection and training of administrative judge For judge and administrative court of first instance, selection periods could be as long as 15 months and use the budget about 2.8 million baht. The number of persons receiving a royal command for the appointment of judge of administrative court of first instance is in the 11 batch is only 40 person and the 12 batch is 19 person. For judge of the Supreme Administrative Court from the general public, selection periods was 13 months. Budget is about 600,000 baht. The number of persons passing the selection process, the latest batch, the 12th batch, is only 3 persons. The number of judges that had been selected through this process is very low. And that's the main problem with our court at the moment.
Let's continue to the title 1.4. I have the solution to the problem of delay in dispensing administrative justice. First, make a selection process for administrative court judges to be more concise, and then accelerate the process of bringing cases to a consideration of General Assembly of Judge of the Supreme Administrative Court, and after that organize a general meeting of the General Assembly of Judge of the Supreme Administrative Court on weekly basis. And the last one, we reduce the step of establishing the framework for scrutinizing draft of court judgment that has been reviewed by the committee in order to speed up the process. For more information, please look in the slide and check the document that the court provides to you, because we have so many statistics shows you from the statistic, the one judge have to handle with around 200 cases per one person. Unless we have not recruit more judge to the administrative court, we have to confront with the delay of the cases management. Let's come to the detail of deliberation of the General Assembly of Judges of the Administrative Court. Lead to the impact as following. First, as of the 27th September 2021, there have been 170 cases proposed for ruling by the General Assembly. And the second deliberation of 157 cases is complete, and 13 cases remain according to the data as of the 2nd March 2022. Then a total of 62 cases relate only the cases that is being considered. And then a total of 95 cases are cases that affect other related cases, and 46 more cases related to a class action suit or a series of cases. 44 cases relate to dispute in the organization of competitive examination to recruit personnel as civil servants. This affects 4 other cases. And 33 lawsuits between university and university employees relating to right and benefit have affected 3 other cases. And the last one, 18 cases of dispute concerning additional payment in regular pension for local government official and affect 39 other cases. There's also a lot of delay cases waiting for the consider of the General Assembly of the Judge of the Supreme Administrative Court. The President of the Supreme Administrative Court tries so hard to handle with this caseload under the authority of the Administrative Court. The most important mission of the Administrative Court is to deliver the justice to the people as much as possible. Let's see to the statistic of admission cases, complete case, and pending case of the Supreme Administrative Court in the past 5 years between fiscal year 2018 to 2022. Let's see the title number 1.5. We have the solution to the problem of uncertainty in diagnosing administrative case of the same nature. The administrative court has the solution as following. Firstly, we set up guidelines for adjudicating administrative cases that are of the same nature or administrative cases that have similar course of action so that the ruling is in the same direction. Secondly, we modify the payment for cases to the committee so as to reduce the problem of distributing cases of the same type to several panels. After that, we classify the type of cases to be assigned to each committee according to its expertise in various types of cases. Moreover, we develop the system to search for information on the course of litigation to investigate cases with the similar grounds for litigation and appropriately distribute the case to the committee. And finally, we try to gather issue of uncertainty in ruling on administrative cases and to formulate guidelines for standardizing ruling of the administrative court. We accept all comments from our sector and try to handle it as much as possible. The judge of the court of the first instance of administrative court have to discuss and consult each other about the same course of cases. The president of the administrative court has some lesson from France and try to share the idea from the French legal system to handle with the problem. The administrative court have no excuse for this problem. We had to handle with this problem by setting the measure to respond this problem under the consideration of the General Assembly of the Judge of the Supreme Administrative Court. According to our solution, we believe that we can handle with this problem and set the standardized ruling of the administrative court. Let's see the title number 1.6 about the measures in response to the COVID-19 pandemic. The administrative court have to handle with the problem of the pandemic of the COVID-19. The administrative court set some measures as following. First, we organize general meeting of the administrative court for the General Assembly of Judge of the Supreme Administrative Court via video conferencing. Moreover, we provide equipment and system to support work from home for administrative court judges, administrative court officials, and related officials. Moreover, because of the COVID-19, we have to distancing. So we determine operation measure for the administrative court and the Office of Administrative Court to provide justice in timely manner for the public and the party in cases. Lastly, we implement the use of information technology to file a plaint, conduct legal proceeding, request copy of judgment or order. Especially, we are try to conduct the General Assembly of Judge of Supreme Administrative Court via video conference as much as possible to avoid the on-site meeting. But however, we have some tasks about the meeting under the online because of some technicals under the legal problem. We need to upgrade our human resources under the conferencing and lectures. The President of the Supreme Administrative Court realized that the upgrade of the administrative case official, administrative court judge, and the related official is the important issue for the administrative court. We would like to present you about the development of information technology of administrative court. There are e-litigation portal, e-court, e-admin court, e-courtroom, mobile application, and case docket retrieval system. According to my experience from France, I saw that in France have the human court. The humanitarian court in France has the important role to handle with some cases. Based on my overall experience, I found that the court in France, they are handled with the cases with the high technologies. For many years ago, they tried to input all information into the online, and they can link some of the information or documents via online. They need to use the outsourcing to support this IT supporting for the court.
As an example, Australia, they were advanced in the IT solution for improving the administrative legal system. In the last few years, we have used the IT system and experience from Korea and China. And due to the incident of COVID-19, we are now progressing very fast to creating the ecosystem which would beneficial to the work of the court. I believe in the public hearing, and I'm open to criticism from the scholars, from all fields of academics. For example, Professor Dr. Prawansak Uwano, who's greatly impact the establishment of the court, and Ms. Kanchanarak, who helped creating the administrative court, and other professors. For example, a former Dean of Thammasat University, Dr. Surapon. He assessed the work of the court and give the court a good grade, just passing. From the perspective of the scholar within the administrative legal system, we can exceed more. We can do more. And now, for the cooperation, especially academic cooperation, is what we like to emphasize. Back in the day when I'm still the Secretary General of the Office of Administrative Court, in our legal system, we import the structure and the principle from abroad. So we should learn from the experience of those countries that we derive our legal system from. Therefore, we're creating a cooperation between those countries. When I was the Secretary General of the Office of Administrative Court, we have a technical cooperation with a lot of international organizations. For example, French government, Konrad Adenauer Stephen Foundation, State Court of Singapore, or Korea, the Court of Korea, who helped setting up our ecosystem. Especially Konrad Adenauer Stephen was the important part that helped creating the Administrative Procedure Act. They helped by inviting scholars to give lectures and share information and experience from this area. Most people might not know, but Thailand is a member of the International Association of Supreme Administrative Jurisdiction, or ISAJ. We were member of the ISAJ since the inauguration of the Administrative Court. But before the inauguration of our court, we would participate in the general meeting of the ISAJ every year. But for the executive commissions, we have given the honor to be the head of special commissions in our regions. In the ASEAN regions, we have been recognized and honored to be one of the executive in the commissions. And recently, the Laos, our neighbor, we helped setting up the administrative court. And we have to give credit for our Vice President, Honorable Justice Suchat Mongkol, who helped educate and setting up the administrative court in Laos. Even though we have different regimes, nonetheless, we have the same goal to provide the rule of law in our countries. In the process of help setting up Laos administrative legal system, we have invite the Laos justice here in Thailand, and we also go over to Laos to give lectures and share our experience. The participant in both in Thailand and Laos, we communicated in Thai, which very common between our two nations, and we feel that we have a close tie between Thailand and Laos. At first, I didn't get my hopes up. I didn't thought that we will accomplish setting up the administrative court. Nonetheless, eventually, we have success in the establishing the administrative court of Laos. Now we come to conclusions. There are one more issues that I want to address. I believe in good governance. And I believe that in order to know what's wrong with their administrative procedure, we should analyze the cause of the administrative case. Back when I was assistant to Professor Dr. Amon Chaitara Sombun, what I learned and experienced then was that when you face an issue or problems in the administrative justice and system, you can suggest and recommend a solution to help resolve the whole issues in the system. For example, the right to get a rental for the government officials. If there are no clear-cut or explicit procedure, we should have a clear and precise descriptions of how to do it, and then we can circulate those procedure to all the organization to promote and create a good administrative practice, a good governance. Instead of doing what we do by resolving dispute, we can make it better by go to the roots of the problems and help resolve the dispute before it's even created, and resolve this from the beginning of the root cause. One time, I was the selection committee of the National Corruption Protection Agency, and I have a chance to initiate a cooperation to help solve the problem at the root cause. Even though we not have been supported by the government, we still create a cooperation between institutions. If we listen and we communicate, we can create a better cooperation and thus help resolve the issues and the root cause. What I have experienced is that a customer or the plaintiff in our court is mostly those who are affected by the tort liabilities or the disciplinary orders by the state audit agency. What have impressed me is that the audit authority of Thailand and the audit organization have shifted their roles as a reviewer into an organization which recommend the good practice or the good administrative practice or good governance to the organization all over Thailand. We switch from corrective institution to the preventive institution. In the past year, the administrative court has been really good at spreading the knowledge of how to access the administrative justice system. Nonetheless, I don't think it's enough. What we can do is we can promote rule of law by cooperation between organization, by not just the corrective measures, but emphasize on the preventive measures. For the roadmap for the 20 years, my term will end this year. Nonetheless, I will pass on our duty and our visions to the next president. This year, we aim to fasten and the case management should be faster, and the implementation of court's order should be done in a time frame. In 2032, we should be the smart administrative and the court excellence that we aiming to achieve. And now, thank you everyone for your attention on this lecture. I have expressed my thought and my experience, and I have expressed my concern and the solution that we can achieve. I have talked about my dreams and my visions, and now thank you all for attending and listen to my lecture. Thank you very much. And now we thank you our
Now we finish the special lectures of the Administrative Court President from the first section. So you can listen to the next section but have no English version via the Facebook Live of the Administrative Court Facebook. Thank you for attention.